Good morning, everyone. Thanks for joining us. My name is Stephen Kelly. Excuse me. My name is Stephen Kelly, and I'm Chief Executive of Manufacturing Northern Ireland. You're all very welcome along to this webinar on the public consultation on the Good Jobs Employment Rights Bill, which has been consulted on at the moment by the Department for the Economy at the request of the Economy Minister, Conor Murphy. This will be a massive bill that the Assembly will be considering through the rest of its current term, and potentially has a once-in-a-generation chance to completely fundamentally change employment rights here in Northern Ireland. It's a very complex bill. It's very long. The consultation document itself runs into almost 200 pages. So because of that, we're incredibly grateful that colleagues from the Employers Federation, Michelle McGinley and Kathryn O'Lone, are with us today. They specialise in employment law, with manufacturers particularly at the core of what they do in terms of their business. Incredibly knowledgeable, which you'll see throughout the presentation today and later in the questions and answers. We work very closely with Michelle and Kathryn in this employment law area, and particularly in regards to good relations within the workplace. So hopefully you'll find today both informative and hopefully it'll inspire you to understand more about this employment rights bill and maybe make a submission. But as a minimum, reach out and get the support of Kathryn and Michelle and the Employers Federation should you require it. This is a recorded event. We're going to be sharing the recording after the event, and we're going to be sharing the slides hopefully as well. Do feel free to ask some questions. Use the Q&A function preferably, or the chat function if that's only available to you. And we'll try to get those questions answered as we go through today. It is quite a beefy bill, as I said. There's a lot of detail to be discussed in terms of the potential changes to employment law in Northern Ireland. So do bear with us. It might be quite a long presentation, but actually this is the quick summary of what is contained inside a monster bill. I'm going to hand over now to Michelle and Kathryn from the Employers Federation, who'll take us through the Employment Rights Bill and some issues that may be of interest to you. But do use the Q&A function, as I said, and log your questions there, and we'll get to them by the end of the day. Michelle and Kathryn, I'll hand over to you.
Thanks, Stephen. Thank you for your very kind words, and obviously for Manufacturing NI for hosting today's webinar and giving us the opportunity to speak to the attendees on the Good Work Bill consultation document. At Employers Federation, we feel really passionately about this consultation document for the reasons that you've already highlighted. This is a very vast, expansive and huge ramifications with the proposals potentially for some employers here in Northern Ireland. So we're committed to contributing to a meaningful response on behalf of employers. And we're really keen to ensure that Northern Ireland is a good place to do business, both locally and then as part of the global economy. Some of you today may be familiar with our organisation, but for those of you who aren't, we are a niche employment law practice. So we're a team of solicitors and barristers who exclusively provide employment law advice and support to employers here in Northern Ireland, Great Britain and in the Republic of Ireland. We support a significant number of manufacturers in Northern Ireland as well as other sectors, and we have, as Stephen has said, have a long-standing relationship with Manufacturing NI and our sister organisation, Make UK. Like Manufacturing NI, we are a membership organisation, so for an annual membership fee, you get unlimited legal advice, support and legal representation at the Industrial Tribunal and the Fair Employment Tribunals if you require it. We work really closely with our members to provide practical and business-focused solutions whilst working within the confines of quite complex employment legislation, which I'm sure you'll agree on. We're delighted to be able to have the opportunity to speak to you today about this consultation document, and I reiterate what Stephen has said. If you want to reach out to either Michelle or I about this consultation, about your concerns, any suggestions that you have in relation to the response, then we would be delighted to hear from you. And without further ado, then I'm going to pass you over to my colleague Michelle, who will begin the first summary of the areas of the consultation.
Thanks, Kathryn, and thank you to so many attending today. It's really good to see a good number turning out to hear about the public consultation document. As Stephen described, it is a monster bill. There's a lot in it and a lot to digest. So really the purpose of today is really to give you a high-level overview of its contents, in the hope that you can meaningfully engage either with your employer organisation, the representative bodies, and feed in back to the department responses. It's crucially important that the employer's voice is heard in this consultation document. The union side will be organised and put in their thoughts and views, and it's, as I say, it's vital really that the employers get their say as well on what will work, and maybe perhaps some of the unintended consequences of some of the proposals. So before I launch into the actual consultation document, I thought it would be helpful just to do a wee bit of a background to where we are with employment law in Northern Ireland. Employment law, as people probably have heard me say, is devolved in Northern Ireland. And by that, I mean Stormont then decides what legislation we have in place. With the stop-start nature of Stormont over the last couple of years, you'll not be surprised to know that we lag behind our counterparts in Great Britain and indeed the Republic of Ireland in terms of our employment rights agenda and an assessment as well of whether our employment laws are fit for purpose at the minute. So it's absolutely apt and right that we are looking at a master or a monster employment rights bill for Northern Ireland and assessing what do we need to make Northern Ireland a good place to work and to level up as well. Now, when Stormont restored in February this year, Sinn Féin were the largest political party and got the first pickings of which departments they wanted to control and which ministerial posts they want. For the first time, really, since the Good Friday Agreement, Sinn Féin are now responsible for the Department for Economy, and the Department for Economy have responsibility for employment law. And it's not controversial to say that Sinn Féin are more into the agenda of promotion of workers' rights than perhaps would be the unionist side, who predominantly have held that ministerial post over the last number of years. So Conor Murphy was appointed as the Minister for Economy in February, and he hit the ground, not just running. I think the department officials will tell you that he hit the ground speed racing ahead and came out very, very quickly with his economic vision for Northern Ireland. And the economic vision for Northern Ireland is based on 4 pillars, the first being the creation of good jobs. And that begs the question of what is a good job, which I'll come on to look at. And that is the foundation of this consultation document as well. How do we create good jobs in Northern Ireland? The second pillar, which is really the flip side of creating good jobs, is how do we grow business? How do we become more productive? And that's his second pillar. The third pillar is to address the regional imbalance. And I know Stephen Kelly is working very closely with the Minister in relation to that aspect. And the fourth aspect is the move to net zero. So those were the 4 pillars, and this consultation document is only one part of the agenda to create good jobs in Northern Ireland. There are going to be other softer measures, but what the department are keen to do is put a legislative framework in place, at least that there's minimum thresholds in place, that everyone has a level playing field. So in terms then of the consultation document, as I say, when you read the consultation document, if you want to read a summary of it, pages 48 sets out all the proposals in summary form. If we could just move back to the previous slide there. So the first objective is the creation of good jobs. And I said that's the flip side of it. It's really, really important, and I'd emphasise throughout that the practicalities of these changes are thought out, and businesses are the ones to say how they will work in practice. So it's important that when you look at the proposals, you think about how it will impact your business. If you think there's any negative consequences or unintended consequences, feed that in either to the response on your own or to one of the representative bodies, so it forms part of the feedback in terms of the consultation. So, as I said, this is all about creating good jobs. And as I said to you, if we move on to the next slide, that begs the question of what is a good job? And the department has has spent some time, and I know they worked with Dr. Lisa Wilson, who's the special advisor to the department appointed by Conor Murphy. How do we define what a good job is? I think we all know what a bad job is, and we could define that, but we might not all agree on what a good job is. And what the department was saying is it's not just based on good money. There are other aspects of job quality, and they decided to use what's called the Carnegie framework in deciding how we measure what a good job is. And there's 7 dimensions to a Carnegie framework, which is set out in that slide. The ones in the italics are the ones that are the themes of this consultation document. So 4 of those dimensions, terms of employment, pay and benefits, voice and representation, and work-life balance, are the themes in the consultation documents, which if we move on to the next slide, you'll see. So there's 4 aspects of that this consultation document is trying to promote: terms of employment, pay and benefits, voice and representation, and work-life balance. I'm going to do theme A and B and take you through the contents on it. And my colleague Kathryn's going to do theme B and D, pay and benefits and work-life balance. As you can see, there's a lot of questions. I think there's 190 questions in the consultation document, and there's a lot of proposals as well. If we move on then to the next slide. In terms of the consultation document itself as well, it's you know, the Stormont at the moment has a mandate that lasts until May 2027, and it's recognised by them that not everything in this consultation document will pass into legislation before that mandate ends. So there's a range of approaches taken in the consultation document. Were policies more fully formed with views sought on how should we go ahead and implement this. We want to do something, tell us if what we're going, the way we're proposing is the right way. There's policies that entail a range of options with views sought on how to best address that, and we will see that, for example, in the zero-hour contracts. In some areas where there's no proposal at all they're doing is gathering information and evidence for further options downstream, and that's really may scope out that may, in the next mandate, it may pave the way for developments then. Okay, so we move into theme A. Theme A is all about terms of employment, and it's all one of Conor Murphy's main things to deal with was to tackle insecure work. And this is precarious work. And if you think of your Uber drivers, your digital platform workers, those who've got no guarantee of hours, this was one of the things that the consultation wants to address, because that isn't a good job. And if you're in a precarious situation with one-sided flexibility, then that's not falling within the definition of what a good job. So it's aiming to explore ways how we can improve the situation for those who have little control over their work, and ensure as well that there's clarity around the terms and conditions of employment, and that employers not only know that employees know, but employers also know what those responsibilities are and live up to them for the workforce. And as well as that, there's some gathering evidence as well in terms of what they will move forward to in the future. So in theme A, if we move on to the next slide, theme A, one of the first thing, and if you read the consultation document right from the very outset, Conor Murphy mentions 2 things. He wants to ban zero-hour contracts, and that has been toned down in the consultation document, and he also wants to strengthen the trade union rights and movement. So the theme A, and he's committed to replacing the zero-hour contracts with contracts that provide flexibility and protect workers' rights. And this has been announced by him since the end of February, just shortly after his appointment. He wants to tackle these zero-hour contracts. In Northern Ireland, the statistics around how many is actually engaged in zero-hour contracts, I think I read Gemma Dolan, who's one of the Sinn Féin MLAs, said there was about 1.3%. The consultation documents suggest there's 1.8% of the workforce in Northern Ireland who work on zero-hour contracts. So it doesn't affect everyone, but it will affect certain industries, particularly the hospitality sector, in terms of the use of zero-hour contracts. So the proposals here are relevant, and if they are relevant to your business, then do think about them and feed into what they're proposing to do. There's a number of options being put out, and the first one being a ban with carve out really for exceptional circumstances, and that's what's in place in the Republic of Ireland. Option 2 is a move to more aligned to a position in, again, the Republic of Ireland, would be banded hours if you work more than the contract states. So that's where if you work a certain pattern of hours, then you have a right to move into a banded hour contract, which can be, I work between 10 and 20 hours every week, and therefore I'm entitled to a banded hour contract of between 10 and 20 hours in a week. And that's a provision that's in place in the Republic of Ireland. Option 3 then is the right to request a more stable contract, and that's what's in place in Great Britain at the moment. So if you operate in Great Britain, you may be familiar with that. So those are the 3 options really, in terms of they are going to do something about 0-hour contracts, and I think that will be in the legislation. It'll either be a ban, which I don't really think it will happen, or it'll be option 2 or option 3. Should we move to a banded hour provision, or should we move to a right to request a more stable contract? Interestingly, at the end of, before Stormont dissolved there, Gemma Doolan, who was the Sinn Féin MLA, put forward a private member bill promoting the banded hours provision. I'm not sure if that will guide the department and how it goes forward, but it is one of the options being considered. Aligned to those 3 options, then, they are also going to consider other aspects which will be tagged on. So if you can ask for a banded hours or a right to request a more stable hours, what should your qualifying period be? Should it be 12 weeks? Should it be 26 weeks? Or should it be a year? And, you know, that you would look back then and say, well, look, that's the pattern of work. That's the number of hours I've been working. It's also talking about what notice should employers give to people in terms of their work, what sort of advance notification should be given, and what should the option 6 there is they're also considering what compensation should be given to individuals if their shifts are cancelled at the last minute, and that's something in place in the Republic of Ireland. And option 7, which is in place in GB, is the ban of exclusivity clauses. I think that means that if you work on a 0-hour contract, it cannot include a clause that you cannot work anywhere else. So that ban is in place in Great Britain. I think it would be pretty uncontroversial, and we probably are likely to get that. So if you're feeding into this area, it's really around what options and what qualifying period and compensation as well. If we move on to the next part of terms of employment, and as I say, 0-hour contracts was one of his big things, so I spent a little bit more time looking at that one. One of the other aspects then in the consultation document is exploring employment status. In Northern Ireland, we have 3 categories of people. You can have an employee, you can have a worker, and that includes an agency worker, or you can have a self-employed person. In the Republic of Ireland, you only have 2 categories. You only have an employee or self-employed. And the consultation document is asking for feedback on whether there is a need to move to a different model of just maybe 2 versions, or should we retain the three categories. Now, there's no proposals on the consultation document on this. It's a very complex issue because your employment status is very tied into tax law, which is not a devolved issue, and the department appreciate that this would be a very complicated thing to do. So at this stage, they're just seeking opinions on what would your views would be in terms of moving to a 2-stage or 2-category employee and self-employed. The other thing in this section is fire and rehire. And this is where I have a real bugbear that bad facts make bad law. And the bad facts are the P&O fiasco. And the P&O fiasco wasn't actually fire and rehire. It was just straightforward fire. But because of the public furore about that, I think the department feel under pressure to do something about it. And they're looking at what should we do in terms of fire and rehire. And fire and rehire, as most employers will know, is the dismissal and re-engagement. In my experience with the businesses that we deal with, it's an absolute last resort. When consultation has been exhausted, you've been trying to change shift patterns, you've been trying to remove a benefit or change a pension, and you have not got agreement, and you've reached the end of the line, where your option then is a dismissal and re-engagement. And in my view, the current case law and the laws around it provide adequate protection. But I do think the department will do something here. I don't think the do nothing option will be attractive to them. They can issue a code of practice, which has taken place or has been issued in Great Britain, although the Labour government has stated that it lacks teeth and is going to strengthen that code of practice, or they can ban fire and rehire. And I think ban, fire and hire is extreme measure because businesses need to be able to run their businesses and make it more effective. So that one is an important one, I think, to feed into. Other aspects under the terms of employment is the redundancy, making it a personal offence for failure to notify. That's in place in GB. I think it's likely to happen here. Don't think it'll be controversial. The written statement of particulars as well, they're proposing to extend it to workers, not just employees, make it a day one right, and increasing the number of particulars to be required. Again, that's in place in GB. In terms of preparation, I think that will be brought on here. In terms of preparation, it's just looking at what your systems are and seeing that you can ensure that written statements are extended to workers and you're including all the particulars that's needed as well. If we move on then to terms of employment, probably the other one then, which the department has made clear that they are closing, is removing pay between assignment contracts for agency workers. And this is where you have employees, sometimes referred to a Swedish derogation contract or Regulation 10 contract, is where if they are an employee of the agency, then you don't need to give priority in terms of a permanent employee in the hirer's workforce. And that loophole that allows you to carve out not give priority of pay to the agency worker and compared to a direct employee at the hirer's end is going to be removed. So if you use pay between assignments, and I think they are dwindling in my experience, I think the numbers are limited, then that's something that you'll need to look at and need to plan ahead and budget as well in terms of any increased costs to the business. In terms of agency workers, there's the last three proposals apply to recruitment or agency and recruitment agencies. It's about giving a key information document in place in GB, likely to be got here as well, and looking at the employment agency inspectorate, sharing information and looking at their enforcement powers. They're only really relevant to recruitment agencies, so I'm not going to deal with in much more detail with them. Okay, if we move on. And I think I'm passing you over to Kathryn for this section.
You're back to me. So this is our theme B, and it's focusing on the pay and benefits. And the Minister's aim then is to improve an individual's overall pay and benefits so that they've all the information, as they say, all the information to understand exactly how they're paid, how it's calculated, because in the department's consultation document, it highlights, if you don't know how you're paid, how do you know you've been incorrectly paid? And pay is one of the most fundamental conditions of employment, and it's obviously it's a very important aspect and one that it needs to be done correctly. So this is between pages 50 and 63 of the consultation document, focusing on 5 areas with 23 questions. This theme B also is highlighting areas which has substantially changed in the last number of years as a result of the pandemic. So working practices, particularly since the pandemic, have changed, improved technology. We have a lot more home working, a lot more hybrid working, and individuals are contactable outside of their core working hours. So there is a concern that these measures may impact on an individual's health and well-being, and therefore this is being considered as part of the theme B as to whether any changes need to be considered. So the 5 areas, there's 3 areas for proposals and 2 areas where the department is simply seeking some advice or representations from those responding. So the areas with proposals are relating to tips, gratuities and service charges, the issue of pay slips, and I dread to say holiday pay reference period, because we all shudder, I think, when we talk about holiday pay now. And areas that are simply seeking advice is in relation to record keeping with respect to the working time regulations, and then the right to disconnect, following on from obviously those change in working practices as a result of the pandemic and technology. So we firstly look at the tips, gratuities and service charges. Now, I don't intend to go into an awful lot of detail in relation to this particular proposal, simply because tips and gratuities aren't something that are necessarily relevant in the manufacturing sector, and that is predominantly what our attendee base is today. it's more relevant to hospitality and services. But just very much as an overview, there's a looking at what's the best way to ensure tips and gratuities and service charges are passed fairly on to the workers or to the employees who will have the benefit or should have the benefit of those that pay. There are two options here from the department. One option is to do nothing, because anecdotally they believe that employers in Northern Ireland are passing on tips and gratuities in a fair manner. The other option is to legislate and to make it legally obligatory to pass on 100% of the tips to workers. Now, they're similar to reforms in Great Britain and the Republic of Ireland. So Great Britain has recently introduced legislation in relation to tips and gratuities and service charges. And in the Republic of Ireland, that happened a number of years ago, where a service industry or hospitality must advertise how they will distribute tips and gratuities and service charges to their workers. And that has to be advertised, and they all need to be passed in 100% on to the worker. So as I say, I don't intend to deal with this in huge amount of detail, other than say that the proposal is to do nothing and leave the current status quo, in the hope that employers are being fair with what they're passing on, or to legislate that. And obviously with the legislation, if an employer isn't passing on 100% of the tips, then there will be a penalty likely put in place as a result of that. The next area in thing B is in relation to pay slips. So employees under Article 40 of the Employment Rights Order are entitled to an itemised pay statement. And that itemised pay statement needs to set out the gross amount of wages or salary that the employee receives, the amounts of variable or fixed deductions that comes out of that salary, that gross salary, and then what the net salary is. So that is what employees, as a minimum, have to receive in Northern Ireland under the Employment Rights Order. A worker, that doesn't extend to a worker, so there's no legal obligation for a worker to receive an itemised pay statement. Now, the proposal then is to extend that right to pay statement to all workers. What I would say is employers don't necessarily engage workers directly. If their employers are engaging anybody, they're done as through an employment contract and employee-employer status. Workers are generally engaged through an agency, and an agency will provide a detailed breakdown of that pay statement to the workers. So I don't believe this is a controversial issue. I don't believe there will be any issue with this being extended to include workers. And in reality, in practice, that is happening. So that's the first proposal. The other proposal then is to ensure, so as it currently sits, Article 40 requires you to set out what your gross pay is, the fixed or variable deductions, for example, tax and national insurance, sub membership, your subs for a trade union, etc. And then the net wages, that's all it requires for the employer to set out in the pay statement. There is a proposal in that itemised pay statement goes further and provides additional information, particularly where the pay fluctuates or the hourly rate fluctuates or changes. So to provide information about the number of hours worked, where the pay varies as a consequence of the time worked. And again, through our practice, through engaging with employers as we do, we don't believe that's a controversial issue. We don't believe that is going to cause any significant detail or issue for employers, because a lot of them are doing that already. But if that is a problem potentially for your organisation, then do detail that in your consultation response and set out why that is an issue, what the concern is, because as Michelle has already highlighted, it's really important when you're responding to the consultation to set out the basis. If there's evidence or reasons why, rather than just opinion, is that you can demonstrate the impact that this would have, and this impact would be either disproportionate or damaging to your business or how you conduct your business. So, as I said, we dread the words of holiday pay, reference period, and holiday pay in Northern Ireland after the plethora of cases that we've had over the number of years, and most recently the Supreme Court judgment in the case of Agnew. And to be fair, this next proposal may well be met with frustration from businesses in Northern Ireland who have for a number of years given the Court of Appeal decision in Agnew been implementing and operating a 52-week reference period, particularly if they have businesses in GB where that is specifically provided for with the legislation. So, because earlier this year, as a result of post-Brexit employment law changes and to ensure the supremacy and general principles of EU law, there were changes to the working time regulations from the 1st of January 2024, which specifically provided that employers must use a 12-week reference period rather than the 52. So employers had just got to grips with the 52-week reference period, and from the 1st of January this year, they were told you need to go back to a 12-week reference period or fall foul of the legislation. And we know from speaking to members and speaking to employers that has caused particular difficulties from a systems perspective, and where they operate a centralised pay system if they operate between Northern Ireland and Great Britain as well. The department is recognising that a 12-week reference period has the potential to turn out probably an unfair and unreflective holiday pay calculation, both from an employee and an employer perspective, because it could be skewed by seasonal peaks or troughs. If there's a period of your business where you're doing a lot of overtime, if the employee tries to take a period of annual leave after that, within that 12-week reference period, their average holiday pay will be significantly higher. So the department is saying, well, we believe a 52-week reference period is more robust and a fairer way and a more reflective way of calculating holiday pay than using a 12-week. And as I said, the frustration will be met by employers because that's what they were doing for a number of years. So that is the proposal from an increase from a 12-week to a 52-week reference period for holiday pay calculation purposes. But we just add, disappointingly, the department hasn't considered the position about part-year permanent workers following from the Harper Trust in Brazil. So very brief recap in terms of that case. That is where the individual was a part-year worker, but were found that they were entitled to receive the full 5.6 weeks under the working time regulations as annual leave, and potentially then putting you in a position where you could have somebody engaged for 3 weeks in a year as a part-year worker and be getting a full 5.6 weeks entitlement. And that was the analogy put forward, as somebody that's engaged for 1 week has then got a full entitlement of 5.6 weeks, which can't be fair. We see that's been dealt with in GB recently, but it hasn't been considered as part of this consultation. And when we met with Colin Jack quite recently as part of another briefing session, he did say that if things aren't included in the consultation document, that's not to say you can't make suggestions and general responses. So in this area, if that's something that would particularly affect your business for part-year permanent employees or workers, then do add that into the consultation response, because that may be something that they will consider at a later date. Sorry. So that's the 3 areas where specific proposals are being made by the department. The last 2 areas are simply areas where the department are seeking evidence, and therefore this is not likely to form part of an immediate change. Definitely not within this mandate, but you can never just tell. So the first area is about record keeping requirements under the working time regulations. Employers must keep records of the hours that the workers are working under the working time regulations, but there's no requirement to record the rest breaks or the hours worked each day. So if you think of your 48-hour opt-out and just keeping a record of obviously the hours that are worked on a weekly period, you ensure that the rest breaks, the weekly and daily rest breaks are being adhered to. The view is the current arrangements lack clarity, and the recent case in the ECJ said that employers should be required to maintain records about the level of detail of these rest periods from an employee health and safety perspective. So the department is taking views from employers, and what they're wanting to understand is, what is your experience of record keeping? Is this an area of that's problematic? Is this an area where requires further legislation, or the working time regulations sufficient? Are they enough to ensure the health and safety and well-being of your employees? Are there disputes in the workplace about hours worked, pay, rest periods? Have you ever had to go into detail and go back and look at the days worked, the hours worked, the rest periods that an individual has taken? Has there been any concern about that? In ROI, very briefly, there is a specific requirement and a very onerous requirement that employers must keep detailed records of the hours worked each day and each week, and they must maintain those for a period of 3 years. At any point, then the Workplace Relations Commission, the inspector, can come in and ask to see those records. So I don't believe we're going to go to that level. That hasn't been suggested or even referenced by the minister in the consultation document. But it's really to garner your views on whether or not there's a requirement to actually make amendment to either the regulations or specific legislation with more detailed obligations for an employer to maintain records. Finally, then, in the area of pay and benefits, it's about the working time regulations and the right to disconnect. So as I said at the outset of theme B, our working practices have significantly changed in recent years. A lot of us are either doing home working or hybrid working. We have technology on our phones, our work emails, etc. And we can get into a position then of responding to emails, reading emails, sending emails outside of working hours. And the impact of that is that we're not taking a sufficient break from work, but also we're potentially impacted on someone else's rest and enjoyment from work if they're receiving that email, that message, whatever it is, outside of their working hours. Rest breaks, as I just mentioned, are dealt with under the working time regulations. And the question from the department is, well, is that still sufficient? Is that, given the change in our working practices, are the regulations still fit for purpose in relation to that particular issue? We're looking at potentially then that right to disconnect and what that would look like. That's something that has been mentioned in GB. I read something on it quite recently, as it's very much a focus of Labour and how they will do that. It was mentioned in the 2021 paper. And now that they've come into power, how are they potentially going to implement that? Is that going to be through a code of practice, a softer touch rather than specific legislation? In ROI, they have the right to disconnect, and they've had that since 2021. But it again is quite light touch, and it's set out 3 areas that obviously the individual has the right not to be contacted outside of their working hours, the right not to routinely perform their work outside of working hours, and penalised for, and the right not to be penalised for doing that. But it is a light touch, as I said. It's no real bite. There's no penalties. So the department is looking, obviously, both sides across the water and in the Republic of Ireland, to say, well, do we need to do something? If we do anything, what would that look like? What impact would that potentially have? Or should we maintain the status quo at this point, because there's not necessarily an issue to be looked at? I would anticipate that at some stage there will be a right to disconnect policy also extended into Northern Ireland, because that seems to be the momentum in GB and obviously, as I said, in the Republic of Ireland. So I'm just going to pass you back to Michelle then, who's going to take you through the theme C on voice and representation.
Thanks, Kathryn. So voice and representation, as I say, reflects that Carnegie framework, and it's about strengthening or increasing the role of the trade unions, particularly in low-paying sectors. And as I said, right at the outset of the consultation document, the Minister makes known that the removal of unfair barriers to trade unions is one of his key aims. Now, when we held this briefing session in person, a number of our companies who aren't unionised came forward and go, well, that doesn't apply to me. Well, it does, and I think it's very important either for unionised and non-unionised workplaces that you read this section and understand what it means and what it could mean for your businesses. Increasing the role of trade unions isn't just in the unionised section, but it's increasing the number of unionised businesses as well. So it's a priority area and a cornerstone of the consultation document. And as I say, Conor Murphy's made it known that that is one of his key aims. And it's all about what he calls is increasing social dialogue, the tripartite relationship with employers, workers, unions and the government. And there's a lot to be credited with that. It worked very well, particularly in COVID, where we had the engagement forum, which was made up of department officials from the regulatory bodies and from the Department of Economy. There was representatives from businesses there, and there was the trade unions, and a number of solutions were brought forward and agreed on in terms of COVID, health and safety in the workplace, and other issues that were brought forward that could be thrashed out and agreed on between all the social partners, and an agreement got. That vehicle is being reconstitutionalised in a sense, so that it will also now be the sounding board for employee rights as well, and that this tripartite relationship between the department, unions and the employers will still exist. And the purpose of it really is to promote effective and productive workplace relationships. All the proposals here are calls for information. I'm not sure whether that means that they're not going to be fully formed and they'll make in, but some of them I think could make their way into legislation as well. So if we look at Northern Ireland as it stands at the minute, we are the highest unionised in the devolved nation. So out of the UK, I think with something like 33.8% of our workforce are already in trade unions. We were the only one in the devolved nations that increased last year. Everywhere else it declined, and that's partly because we have a very high public sector workforce as well. But the increase in the role of trade unions is very much about the private sector and increasing the role there. So we move on and we look at some of the proposals that's been put forward. We move on to the next slide. Previous slide, sorry. Okay, so under the very first aspect of it about workplace access, at the moment, the law is that the trade unions don't have a general right to access the workplace. They can only access the workforce for certain defined reasons or with the permission of the company. And you know that if they're coming along to represent somebody or accompany somebody to a disciplinary grievance, then they're allowed to come along. And what the consultation document about is looking at is, well, can we increase their access to the workplace so that they can come over and above those defined periods? And what they're looking at is the position in New Zealand. And in New Zealand, trade unions have a general right to access a workplace that can only be refused on a reasonable basis. So, and that applies not just to unionised workplaces, but to also non-unionised workplaces as well. So in a non-unionised workplace, they can ask to come and you have 2 days to reply. If you don't reply, then it's deemed to be accepted and they can come along. And the purpose of their attendance is to increase the number of people to be trade union members. So that's one of the things that's been looked at here. Should we increase the workplace access for trade unions? And if not, what's the difficulties doing that? What would be the impact on the business and what would be the good reasons for not doing it? So that will be an important one for businesses to think out. As I say, it applies to unionised workforces, but it very much applies as well to non-unionised workplaces as well. It is talking about should there be exclusion to that for micro or small businesses. Micro businesses are those with less than 11 and small organisations I think are defined as up to 50. So it is thinking, should we, or is it 20 I think, should we have a carve out for small organisations in terms of that workplace access? Then the other aspect onto this voice and representation is trade union recognition. And as you know, trade unions can ask to be recognised, and you can do it on a voluntary basis. And if it's not agreed voluntary, then they can apply to the industrial court to force regulation through a statutory procedure as well. That can only happen if they employ at least 21 employees. So workplaces that have less than 21 employees, they can't apply for statutory recognition because they don't meet that threshold. And what the department is looking at, should we decrease that threshold to 11 employees? Now that probably won't apply to most of the businesses attending today, because I think you all tend to be medium to larger size, but it is, again, it's all about increasing the union representation throughout Northern Ireland. The next aspect is collective sectorial bargaining, and you may ask yourself what that is. For the older ones amongst us, you may remember the national agreements that were in place some time ago and how horrendous they were to operate and practice. Peter Block in our office still has nightmares over some of the national agreements in place. But The collective sectorial bargaining, at the minute in Northern Ireland, there is no collective sectorial bargaining except for the agricultural sector. And what this means is that in any particular area, so if you think of electrical manufacture or engineering, for example, that instead of bargaining on an individual level, it's taken up to a national level, and there's a regional agreement reached between the union and representatives for that sector on what the terms and conditions and the pay award and the holidays and any other changes that would be agreed on an annual basis. And that's what they mean by sectorial bargaining. It's done at that sector level rather than at that low level as well. Again, there's no proposal being put forth here, and it's really just about gathering information that might pave the way in the future. So if you have experience of any sectorial bargaining from the past and national agreements, very interesting to hear your views on what worked well and what didn't work, and whether that would be something that would be appropriate for the modern workplace today. The next thing then is balloting notice. So in terms of balloting notice at the minute, if a union is going to call a ballot, they must give you 7 days. And I think that's 7 calendar days that they're going to call a ballot, and they're on about reducing that to 5 days. Now, in the consultation document, the reason for reducing it to 5 days is that the trade unions have asked for it to be reduced for 5 days. It doesn't give any rationale for why that would be necessary. 7 days is extremely short time. 5 days, I think, is even shorter. So it would be, again, I think businesses' feedback on that one will be that 7 days is the more appropriate time frame. It's also as well when you are notified that there's a ballot going to take place because industrial action is potentially going to be called. The union at present have to give you a sample of their balloting paper, and the importance of that is that the questions are asked in a non-leading way, that they don't suggest that the answer. So, do you agree to industrial action of a strike, less than a strike? And it doesn't influence the answer that they want. So if the requirement to remove the sample paper was taken out again, you wouldn't see that ballot paper. And I think that's an important safeguard as well for business to see the ballot paper. So I think that's what our response will be, and I'd welcome any other thoughts on that from attendees as well. If we move on to the next slide. Under voice and representation, then they're also looking at the protection for representatives of the union. So if the union are acting in a workplace, they are protected against detrimental treatment. And what the legislation is, or the consultation document is looking at, is that fit for purpose? Do they need any additional protection? Should there be any other law put in place that would prevent you taking action against them? For example, they can't be treated detrimentally if they've been acting in their capacity as a union member in terms of their representing somebody in a discipline or a grievance meeting. Then, as well as the representatives, then they're looking at the non-representative union members' protection for employees who take part in industrial action. So if your employees are taking part in industrial action, then for the first 12 weeks of that industrial action, you cannot dismiss them. And you can, and they're asking, should that be extended? Should that 12-week period be extended even further? 12 weeks is a very long time in my view. I know businesses that have had individuals on strike for 12 weeks and they only come back in when the agreement hasn't been reached at the end of the 12 weeks. I'm not sure again about how useful an extension beyond 12 weeks would be, and I'd be interested to know businesses' views on that as well. The consultation document also talks as well about, at present, people taking part in unofficial industrial action that hasn't gone through that machinery of balloting, noticing the requirements and meeting the statutory framework. At the minute, people taking place in industrial action, unofficial industrial action, can be dismissed fairly. There's no protection in terms of that. And what the consultation suggests is that, should we be looking at that as well? Should we be looking at protection for unofficial industrial action? Probably one of the the non-controversial things in this section is the electronic balloting and allowing e-balloting. At the minute, the trade unions are stuck in the dark ages that if they hold a ballot, it must be a postal ballot. They must send it out a postal address, cannot do it by emails. That is because the legislative framework prohibits them doing it by electronic basis. I think we all agree that we can move to the modern day and electronic balloting should be allowed. But as part of that, then they're looking at removing the role of the independent scrutineer. So if we move from postal ballots, do we still need that independent scrutineer to determine if the process has been done properly? And they question, well, what is the role of an independent scrutineer if we move to electronic balloting? In my view, I think there still is a role there for the independent scrutineer, just to check that emails have been sent, there's any bounce back, that everyone who is a union member has been sent an email, it is to an up-to-date address. So I do think there is a role there still for the independent scrutineer to give some sort of assurances that it has been done correctly. Because as we all know, industrial action has a huge cost on businesses and employees, and it's important that there's confidence that everything has been done before employees actually take the step of going out on strike, if that's the case. So voice and representation, then moving on again, one of the aspects of the consultation document looks at how can we facilitate productive workplace relationships. And I think all businesses would agree that there is definitely ways in which we could set down codes of behaviour and standards of behaviour that would happen in a workplace between unions and businesses. What the department is looking at here is the code of practice that's currently in place in New Zealand, and that code of practice suggests a number of things about how collective bargaining should happen, and sets down standards of behaviours. For example, it says that for the first 40 days in any negotiations, employees cannot go on strike. But then it also sets down then difficulties of what happens if an agreement is not reached, at what stage, what happens, and it doesn't suggest it in the code that at any stage the company can go direct to employees. It provides for dispute resolution processes to arbitrators outside of the workplace to try and resolve it. We do have something similar in place in Northern Ireland with the Labour Relations Agency, and I do think the Labour Relations Agency are looking at a code in this area about collective code of practice in terms of collective bargaining and what is good collective bargaining. There is merit in this. I'm not sure if what the New Zealand is proposing is right for Northern Ireland. I think it goes too far and takes away any sort of control between the individual parties and removes it up and escalates it to external bodies without really exhausting the internal process. But I do think there's merit here in something being said about workplaces and businesses' experience of what is good collective bargaining, what we'd like to see in a code, if there is going to be code or statutory or just guidance, what we'd like to see a code, what works for us, what doesn't work. And that's, I think, important from businesses as well, particularly in light of some of the Supreme Court cases there on collective bargaining, where at what stage can we say the collective process has been exhausted? We're not going to reach agreement. We can go directly to employees and put an offer forward to them. Some sort of clarity around that end of the process, I think, will be welcome from a business perspective. And any other views that businesses has, I would really welcome that on this area. As well, then, under voice and representation, it talks about the information and consultation requirements, and these are called the ICE agreements, and they're a hangover really from the European Union. But at the minute, for establishments who operate in two different establishments or undertakings, employees can ask for an ICE agreement, as in requires the business to consult with the employees about changes that's going to happen in it. At the minute, it is on the basis of the undertaking. So if the legal undertaking has 200 or 2,500, you need 10% of the workforce to ask for that ICE agreement, which is 250 employees. If, for example, in Northern Ireland, there's only 10 employees, then they're never going to get an ICE agreement for them because there's only 10 employees. So it's all about changing the word from undertaking, as in the legal undertaking, down to establishment, very similar to the way we do redundancy situations and what impact that would have. Should we change it from undertaking and move it down to establishment? As well as that, then under the information and consultation, they're proposing reducing the threshold from that 10%, so from 10% of the workforce to only 2% of the workforce. So if 2% of the workforce, think of your workforce of 100, if 2 employees ask for an ICE agreement, that would be sufficient in the proposal to get one in place, and whether that would be appropriate as well. 2% to me seems very low. So it does. So again, it's having to think about that and what it would mean in your workplace and if there was any unintended consequences of it. Moving on then in terms of voice and representation. The last two things, I'm not going to look at the public interest disclosure, but in terms of transfer of undertakings as well, there are some very good sensible proposals about exempting micro businesses from the transfer of undertakings and informing and consulting directly if you have fewer than 50 employees or transferring fewer than 10 employees. We've all been or I've been in the case where advising companies and there's a transfer of 3 employees and I'm going, you need to inform and consult, but before you inform and consult, you must elect representatives. And they're going, but there's only 3. And they go, but still you need to invite a representative. And if nobody's nominated, then you just say that they're electing themselves. So that's nonsensical. And the department is talking about removing that so that employers can consult directly with the employees if they have fewer than 50 employees or they're transferring fewer than 10 employees. It would also clarify that the TUPE only applies to employees, not workers. There's a typo there. But in terms of that, again, that's a case law has sort of thrown a bit of confusion in there that maybe it extends beyond employees to workers. And then removing this obligation to split contracts of employment. This is an absolute nightmare where, for example, one contractor has lost the contract and the service has now been split out over three different providers. And there's case law to suggest that that person's contract of employment can be split over 3 different employees. No one likes it. It's a practical nightmare, and the consultation document is proposing removing that, and I think that's a good sense proposal as well. There are other proposals in the 2014 and 2016 changes that happened in GB that aren't mentioned directly in the consultation document, but you will see in the questions they are saying, is there anything else in TUPE that you would like us to do? And I think the feedback will be, can we align ourselves to Great Britain, because they've made a number of sensible changes that would work well for businesses in Northern Ireland. If we move on, I think we're back to Kathryn for this section.
We're back to me. Now, on one hand, you might be glad that they were on theme day in the last of the areas of the consultation. Unfortunately, this is a weighty section, a weighty theme with lots of kind of very detailed proposals, which for HR practitioners, if that's the majority of our attendees are today, may cause difficulty in thinking, how are we going to implement all these changes, particularly if they come at once in the workplaces? How are we going to prepare for that? So our theme D is in relation to work-life balance. So the final section, and a weighty one, and can be best described as a catch-up for the changes that have happened in recent years in GB as a result of the private members bill. So we're very much replicating what has been done across the water. So again, if you operate within GB, if you've got business in GB, you may be familiar with the proposals already as in terms of what the department are suggesting to introduce. And the key component, coming back to the Carnegie framework and the minister's ministerial aim and objective, is a key component of good jobs. It's not just the pay and it's not just the representation. It's one that allows us to balance our work, which would be, employees really enjoy, but with our family and our private life, particularly if you've got competing interests from children or current responsibilities or hobbies and social activities, particularly from the pandemic. Employees did enjoy and enjoyed more of that flexibility with the hybrid and home working arrangements. And what the minister's recognising that that's the best way to do that is to balance the work and family life and the private life is through flexibility in the workplace with policies and procedures that are supporting work and families. And the minister believes that it not only will this help an individual, help the worker, the employee, whoever it may be, but it also has greater impact and ramifications for not the business, but also the society and the economy, because you will encourage people to remain in the workplace. You will encourage people to return to the workplace if there is that flexibility, and that will, particularly for the economically inactive, that will encourage them back into the workplace if they believe that their employment or their working relationship now will have a bit more degree of flexibility to suit their individualized needs. It's spanning 50 pages with 38 questions and 5 areas that we're going to focus on today. What I would say is we are catching up with GB insofar as the changes that they've already implemented. I heard this morning, I was listening to the news and reading an article, and there's a proposal from Labour that there will be a 4-day working week, and that's something that they're very keen on. So we may find very quickly, if we do catch up, that we will soon end up lagging behind again. The proposed changes then in this consultation to the work-life balance are in respect of flexible working, carers leave, neonatal care leave and pay, the extension to protection from redundancy for pregnancy and family leave, and then paternity leave. So I'm going to take you through each of those sections in very much a high-level overview, just because of how detailed they potentially could be. The first area then I'm going to look at is in relation to flexible working, and we're almost replicating the changes that were introduced in GB from the 1st of April of this year. So briefly, where we're set at the minute with flexible working requests, all employees in Northern Ireland can make an application. You have to have 26 weeks continuous service, and you make one application within a 12-month period, with obviously the right of appeal, and that needs to be considered within a total 6-week period. So the 28 days to meet with you to discuss your request, and then 14 days to give you the response. And currently, as it sits, where you're making an application for flexible working in Northern Ireland, then you must set out in your application the potential impact that you foresee your flexible working request having on the workplace and how that could be minimised. So the burden is very much put on the employee at the outset to demonstrate, is there an issue with their request? And there's a view that that has been framed in a more negative way. So the Minister believes, and very much supported by research, that there are multifaceted benefits to flexible working, as I just touched upon, the individual, societal and economic, and making Northern Ireland more economically active, particularly from women. And they believe that increased flexibility for females will potentially close that gender pay gap. So the proposal then in respect of the consultation with regards to flexible working is to make the right to request flexible working a day one right. And potentially then the issue will be, could you apply before your employment even begins in terms of that recruitment process? So the right to request flexible working from a day one right. So there's no eligibility service requirement in respect of that. You will then have the right to make 2 applications within a 12-month period, and that would include the appeal. And there will be the removal of the potential the removal of the obligation on the employee to remove the potential impact of the request. So as I said, neutralising that and not framing that in the view of a negative way. Now, what I would say, and given that you're best placed, if you're a HR practitioner, you're best placed to know the real effect of this in your workplace, but from a very much an immediate off the mark, I would say that if you're increasing the scope of who can apply and increasing the volume, the number of applications that can be made, immediately you're going to result in an increased volume. And that's going to have to be addressed by the HR team or by your management. So that's going to lead to an increased volume of workload. And there are questions that are not clear, or areas that are not clear in respect of, whilst it says the second application shouldn't be looked at until the first application has been closed off, if that second application relates exclusively and identically to the first application, which has been considered and rejected, should the employer be made to consider the identical application when it's already determined that it can't facilitate it? So it's very clear that, we anticipate that this will come in. It is keeping pace with GB, and potentially, as I said, has the potential to lag behind within the foreseeable period. Ahead of the Republic of Ireland, where they're flexible working, the right to request flexible working is perhaps more restrictive than what we have. it's limited to those with care and responsibilities and parents, but very much anticipate that it will come in, and it is going to give an increased workload. So if you think of the areas in your workplace when you're dealing with flexible working requests at present, what impact these proposals will make to that, will impact on that, and feed that into your response, or where you'd require clarity or more information or more guidance in respect of it. The next area that has been proposed by the department and is a completely new right is the right to carers leave. And this will require new primary and secondary legislation. So the aim of this is to support employees who balance care and responsibilities with work commitments. A plethora of research to demonstrate how many significant number of individuals in Northern Ireland, working individuals who have care and responsibilities. I think the statistic is 51% on the last survey. So 51% of those individuals in the working population have care and responsibilities as well as working full time, and that's quite significant. And again, the Minister's view is if the Northern Ireland executive, Northern Ireland employers support individuals with working or with care and responsibilities, that can only ensure that that individual will remain in the workplace, will be happier in the workplace, will benefit themselves, benefit their employer, and benefit the economy in general. So the proposal is this an entirely new right for carers leave, which would be 1 week unpaid leave, and a week will be then whatever working week for that individual employee. So if it's a 3-day, the individual works a 3-day week, they'll be entitled to 3 days off. So it's subject to the working arrangement of the employee. And that will be to provide care for a family member or a dependent, so not necessarily somebody that lives with them or is a family member, who have a physical or mental condition likely to last 3 months or more, so akin to that definition with the disability legislation. And the department is intending that the definition of a dependent will broadly mirror that for the dependent relationship for time off for dependents, which you will be familiar with and we've had for a number of years. But the view is that dependent will be widely defined to allow for, particularly in Northern Ireland, where we operate in rural communities, and you may be providing care for somebody who lives quite close to you, that's not related to you, etc., that would be more broadly defined. Care is also to be defined widely, so it doesn't necessarily need to be taking the individual to a medical appointment. It doesn't have to be physical care. It can be taking them to appointments such as the banks, the opticians, whatever it may be, other planned appointments, and to be sat alongside the existing framework for time off for care and responsibilities and time off in general that an employee may have, such as I said, emergency time off for dependents, flexible working requests, and then your statutory annual leave. It is proposed that the 1 week period will be either individual days, can be taken in individual days or for half days to maximise flexibility. So would you allow that individual to take, for example, a morning off or an afternoon off to take the person to an appointment or to provide that care, whatever they may need. The notice requirement, it's proposed that you would be given twice as much notice as the time off that you require. So if you require a day off, then you have to give 2 days notice or 3 days, whichever is the earlier. So again, when you look at the intention of this, right, it is to provide care. It's not for an emergency situation. It is perhaps for more planned or routine appointments. It should be possible to give more notice to the employer about that. And if it's a routine arrangement, such as every Monday, I am responsible to bring food to this individual, to provide care to them, to get them washed and dressed, etc., then that could be utilised more under the flexible working arrangement, where it is a routine obligation or responsibility that you will have each week. So that's just some of the issues in respect of the carers leave. Again, some concerns that we're hearing, and when we've been in discussions with our members about this, is that if the whilst it's unpaid, it's proposed to be unpaid at this point, there's definitely rumblings or a momentum that at some point the executive have an appetite to try to make this a paid time off, or else it won't be necessarily utilised. Now, if it becomes a paid period of leave, then there will be evidential requirements, because you potentially could have somebody abusing that right if they're going to receive the pay. And at that stage, you need to look at, well, who makes the determination about the care and responsibilities? You potentially are looking for evidence, and that is sensitive data in relation to a third party. How do you manage that? So there are issues that employers need to be thinking about on their radar and feeding in their concerns if this happens, and if these changes do come in with the paid element of it. How are we going to manage that? Our next brand new right that is being proposed by the department is the neonatal care leave and pay. And this is where, when you've had give birth to a baby, or the parent of a baby who's been born, who has received neonatal care of at least 7 days within the first 28 days of their life. So when your baby's been born, if they have received neonatal care that is extended beyond 7 days within that first 4 weeks of being born, you potentially will have the right, and it's proposed you will have the right to take that leave at another time. So that you can enjoy that quality time, that bonding time with your child, with your baby, when it's the care has been finished. And that is proposed to be a maximum of 12 weeks, because what the department is recognising, that particularly from a paternity leave perspective, if an individual has taken their 2 weeks paternity leave and the baby has been in neonatal care that entire time, that employee has not had the opportunity to either support the mother or to care for that baby once the neonatal care has ended. And the more pressure then to get back to work, particularly from a finance perspective, will mean that is going to be a paid leave at the same rate as the other family-friendly leave rates that apply. You can't stop and start your maternity leave, so this is intended that it will bolt on to the end of the maternity leave and bolt on to the end of the paternity leave, when obviously that comes to an end. What employers may find, in looking at across in GB, is that you will have individuals, employees, if they can take the maximum of 12 weeks, if their baby has been received neonatal care for 12 weeks, they could be off potentially with statutory pay for a 12-month period. And what we're also going to touch on, and this feeds in quite neatly with the enhanced redundancy protections, is that you could have a situation that an individual could have potentially 2 years if the neonatal leave bolts on at the end of the maternity period and as a protected period. You could have an individual who's nearly protected for 2 years from the birth of their child from a redundancy perspective, and how you manage that in the workplace. Again, similar to carers leave, it's what evidence or notice that you're going to require this isn't clear. In the consultation document, it talks about sensitivity and an informal notice, but how do you manage that in the workplace? What is defined as an informal notice or informal evidence? And how do you have that consistency without potentially then exposing yourselves to complaints that an individual has been treated less favourably because of taking neonatal leave in the workplace? So that's again a concern for employers. They want more clarity and more guidance as to what notice should the individual be given, what evidence are we going to require to demonstrate that this baby has been in neonatal care, and how you manage that sensitively, because they may have received neonatal care for a week. The individual could be trying to claim for longer than that, and these are potential scenarios that may arise in the workplace if they want that period of paid leave to extend their maternity or paternity leave. Touched on this briefly a few moments ago, but there's a proposal from the department to extend the protection that a female has when they are off on maternity leave from a redundancy perspective. So as it currently sits, if you're off on maternity leave, you have your preferential treatment in redundancy exercise. So you're offered your first offered alternative employment. So you're not safe from redundancy. You can still be made redundant, but you'll be offered the first alternative employment compared to your colleagues who are not on maternity leave. So the department is proposing for those who have returned from maternity leave, adoption, or 6 or more weeks of shared parental leave, that your protected period will run from 8 to 18 months from when the child is born, stillborn, or expected to be placed with adoption. So as it currently sits, you could take a maximum of 12 months maternity, statutory maternity. You'd have that 12 months protection. The proposal is that it would run up to a maximum of 18 months from after the child has been born or placed with you with adoption. So that's a very extended period. From a maternity perspective, yes, it is longer. I don't foresee that's the area which will cause the most problems. What I anticipate, and what this is the general view, is that the concern and the conflict may arise when you have an issue of shared parental leave. So if there's workplace murmurings of potential redundancies, particularly if you're in a collective process and you're engaged in a collective consultation period, that an individual may take shared parental leave for an extended period to fall within the scope of that protection, and how that places them in conflict with the individuals who are off on maternity leave. Is there a preferential, order from the paternity leave, and if there's a conflict in respect of that? So there are issues that, again, you may require some clarification or guidance on. And finally, very briefly, and may not be so controversial given the very short period of paternity leave that exists at this point, but there is a proposal to change from the current 2-week continuous block of paternity leave period that has to be taken within the first 56 days of the child being born to 2 single blocks of 1 week, or 1 block of 2 weeks that you can take any time within the first 52 weeks following the birth or adoption of your child. So rather than having to take 2 weeks in a block, you could choose to vary that up and take 1 week at the beginning and another week at a later point, perhaps as your partner is returning to workplace and adjusting in at that period. There's also then the proposal to reduce the notice requirements for paternity leave to 28 days for each period. So again, I don't envisage that to be a massive issue for employers, but given the short period of leave, but you know best on how this will work within your particular industry, within your particular sector, given the makeup of your workplace, etc., and the work that you do. And if that is a concern, you demonstrate to the department why you have that concern and the evidence for that, how it's worked in practice so far. I'm going to pass you back to Michelle, who is going to just sum up where we're at with this consultation and the next steps.
Yes, so it is an absolute mammoth consultation document, but there are, as I say, we lag well behind GB, so there are a number of things that's not in it. The gender pay gap reporting is not there because that does not fall to the Department for Economy, it falls to the Department for Communities. I spoke to them, I think, at the end of June, and they said that regulations will be issued in due course. Updating discrimination laws, and I did see there was a number of questions about the monitoring return. It's not the Department for Economy, and this is where Stephen mentioned a joined up approach. It falls under the Executive Office. They have a questionnaire out at the minute regarding whether our equality laws are fit for purpose. I think it's on up until Friday next week. So anything in relation to that would fall under their ambit, but I do think there's merit in putting in any issues you have with the monitoring returns, and I know there's many from our members as well, even about the forced classification of people who don't want to be classified into perceived categories of communities. Then do feed it into this consultation. Apprenticeship levy is a vexed issue in Northern Ireland. I think it's a vexed issue across GB. It's a reserved matter in terms of the collection of the levy. Now, I did see that the Labour government is proposing to reform that and review it. The distribution, I think it then goes back to Northern Ireland and how it's distributed, and we're allocated an amount based on the Barnett formula. So the apprenticeship levy is an issue. We could just go back there, Kathryn.
Oh, sorry.
Sorry, thanks. Domestic abuse and safe leave, there's a separate consultation document out on that, and it's up until the 27th of the September as well. That's closing. Reducing the consultation period for collective redundancy from 90 days to 45 days would be something I'd love, and I know a lot of business in that position would also love it. 90 days seems extremely long. GB's got 45 days, and ROI's got less again. I know people are on about the 2-year backstop for deduction claims, where you can only claim back if, for example, your holiday pay claim, if you can't get it, that you could only go back 2 years. I think that's highly unlikely that we'll ever get that in Northern Ireland. But if that's something you feel strongly about, I think make your voice heard or feed into one of the representative bodies. Atypical working, Kathryn's mentioned. Now, when this consultation document was put out, it was put out on the 1st of July. And if everybody cast their mind back to July, the 4th of July was the election day and the Labour government was elected. I think when the consultation was drafted, Labour's manifesto wasn't available, and it looked like it was ahead of its time in terms of what was happening with GB at the time, which was under a Conservative government. Since then, Labour has come out with its proposals, which are obviously quite, I apologise for the dog in the background. We must be getting a delivery man. But Labour's proposals are quite quite advanced, if we could say that. They talk about removal of the qualifying period for unfair dismissal and making it a day one right, a 6-month time limit for bringing claims, and other aspects. They're not in this consultation document, simply probably because of the timing. I do think what happens in GB will influence. It's not that we will go that way, but I think it will influence the directive the direction of the department as well. So we could see things not in this mandate, but perhaps in the later mandate. So if we move on, in terms of timeline, this is the most significant consultation in Northern Ireland for as long as I can think. We've had other ones in statutory procedures, but nothing as pivotal as this one. Northern Ireland is made up mostly of small and medium-sized business. Some of these proposals might have a huge cost to business and a huge administrative burden, and I think that needs to be thought out as well. In terms of realism, the department's very cognizant of the fact that their mandate ends in February or May 2027, and that's a very tight timescale to get things past the consultation part into proposals, debated in Stormont, and even passed into legislation. So it's unlikely that you will see any changes for at least a year, and if more like 18 months. There are maybe some things that require only secondary legislation that they can change quicker, that might come through on a quicker level, but the bigger the change, it will probably be a year and a half down the line. But the groundwork is there for more pivotal change later. So there's calls for information, gathering information. And I think if we do come back in the next mandate, I wouldn't be surprised if Sinn Féin take the Department for Economy post again to continue this agenda that they have at the minute in terms of increasing workers' rights and strengthening the trade unions. So the groundwork's going to be done, and then we could see more pivotal change later. Many operate GB in Northern Ireland, and it will help you because a lot of the proposals are keeping pace with GB and also ROI. There's as well as east-west, we're looking north-south. And some, if you operate in ROI, things like the banded hours provisions and other proposals, you will understand how they work. And you might have practical experience as well of difficulties that you have that you can feed into this consultation, that we can make maybe our legislation even better than that is in place in the other jurisdiction. But as I say, you can't do that unless we hear the employer's voice. And it's really, really important that your thoughts and your comments, there's no silly comment, but if your thoughts and comments are fed on either to representative bodies or you put in an individual consultation. I know Stephen or myself would very much welcome any comments people have on the matter. Consultation closes at 30th September, so we have a month to get the replies. And as I say, reach out if you want to speak further about the issues.
Michelle and Kathryn, that was a tour de force around what is a enormously complex, hugely significant, and definitely environment changing piece of legislation as employers. You have managed to distill down such a complex document in a really digestible form, and I can't thank you enough for that from my own perspective, never mind, I'm sure, for others watching in online. There were a number of questions, excuse me, there were a number of questions during the presentation in the chat, and you've found time to answer those as we've gone through. But from my perspective, I think what is really important here is that people do start engaging with this consultation. Even if it's only just one particular area or one particular issue, or other ideas which you think that the department really need to be considering as part of this. This is going to change the employment rights and legislation environment in Northern Ireland for the next generation. And it's important that people engage because of that. But equally, this is going to change how we, and the nature of how we do business in Northern Ireland. And it does have an implication, it does have implications on other parts of government, not just for the Department for the Economy, but other government agencies and departments as well. So there are, and this is an opportunity for people to go, do you know what, this is something that's really bugged me. This is something that just gets in the way. This stops us having good relations within the workplace. This isn't the right route to go in terms of improving relations in the workplace. But also take the opportunity to actually explain to colleagues in the civil service, ministers and others, that actually we're in such a hot business environment and a hot recruitment environment right now. We're just getting people is incredibly difficult, and becoming the employers of choice means that employers are investing in their people and investing in good relations within the workplace. And that means that lots of the things that are in this consultation may already be actions that businesses themselves are taking in their workplace in order to be that employer of choice. And there is a danger here. I suspect that government will try to legislate for stuff that business is already doing. But by legislating, you create an environment where the success of what you're already applying within your workplace becomes less likely. So do, when you're reading through the consultation, look at it and go, do we need to legislate in this area? Would this be better served by the addition of guidance? Would this be better served by beefing up the Labour Relations Agency and giving them particular responsibilities? If there are areas that cause very deep concern, particularly around the evidential requirements, there's some incredibly sensitive issues that employers struggle to deal with all the time that may be legislated for now, that may require employers to have conversations with members of their workforce that the members of the workforce themselves will be deeply uncomfortable with and will probably be unlikely to want to share. So if there are evidential requirements that cause you concern from a good employer's perspective, do flag those up as well. Happily, all the questions were answered as we've gone through. I don't see anything that we've not had an opportunity to discuss in terms of the excellent presentation that Kathryn and Michelle have just presented us with. Michelle, I'm going to hand over to you just to kind of finish off. The Employers Federation and Manufacturing NI and Make UK, from that perspective, have a very good and close working relationship, and we value that enormously. If people wish to get into more detail on this with you as an organisation, or if they've other employment issues, what's the best way for them to get in contact with you?
Yeah, our email address there is in the last slide, info@EFNI. I'm on LinkedIn as well. Most people, I think, had a look through the list. I think I'm connected to most people on LinkedIn. So reach out. If you have a comment, any comment, certainly welcome it, or you want to understand our services more, please do contact us. As I say, I'd really encourage employers to speak up and voice what their views are in this consultation document so that we can get a really good response back to the department.
Excellent, Michelle. Thanks again to Kathryn and yourself for that presentation. It's taken a massive document and distilling it down into something we can all hopefully engage with. We will be sharing the presentation, hopefully, but certainly the recording after. I'm conscious that there was a massive amount of information in there. Do take time to review it and share it with colleagues as well, so that they understand what's coming down the line. Thanks very much, everyone. We'll see you again.
Thanks, Stephen.